Mr. Speaker, enlistment into the military in the late 1980s and early 1990s required everybody to sign a statement. And that statement asked the question as to your personal sexual behavior. Were you a homosexual? Now, this had been the policy not from the Vietnam War, the Korean War, World War II, World War I, but back to George Washington. In different variations, the prohibition on certain behavior excluded people from the military. In order to get into the military, Mr. Tracy, Thorne-Begland would have had to sign a statement, no, I am not. Yet, when you read the biographical statement in the Richmond University alumni, he indicated, he talked about he was struggling with the secret of his sexual orientation. Now, didn't say he was struggling with an ambiguity. It was the secret of his sexual orientation. Now, you can have that in this country, and you're not going to be chased down on the streets. But when you answer a question that is false on an application, that calls some things into question. Moreover, he had to take an oath of office. And that oath of office indicates that you would obey the lawful orders of superiors, that you would abide by the Uniform Code of Military Justice, and that, furthermore, there were 16 prohibited things that you could not do if you were under these circumstances. One of them was to participate in any radio, television, or other program or group discussion as an advocate for or against a partisan political party, candidate, or cause. The applicant or the nominee went on national television, Nightline, in uniform, and announced his personal behavior. That was in direct violation of the application, of the oath of office, and of this right here. So it wasn't for telling the truth that there's a problem here. There's a question as to whether or not the oath of office is seriously taken. Moreover, we have in the Virginia Constitution a clear definition of marriage. And you are to take an oath to uphold and defend this Constitution. And when you state that you're in a relationship that is a contradiction with that, I don't see how you can be a judge. For example, if somebody were a polygamist, you could not take an oath to uphold and defend the Constitution because your actions would be in violation of that. Moreover, in the short biography that was passed out to members, at least of the Republican caucus, I note a number of omissions. Omitted was Thorne versus U.S. Department of Defense, in which his claim that he had a First Amendment right to this kind of behavior and actions related to it was rejected. Moreover, the other activities which were not mentioned include NBC Nightline, May 3rd, 1993, Richmond Times letter to the editor, May 26th, WAVA Television, 9/21/11, RVA News. If you want to be an advocate, that's one thing, and you have a First Amendment right and privilege to do it. But having already taken an oath and violated it, why would it be any different now, especially if one has announced that your own behavior is in violation or in contradiction to the Constitution, that we should accept that? Now, the gentleman apparently is doing a good job as a prosecutor, and that's fine. But members in here who took an oath of office to defend this Constitution, and especially if you say you supported the marriage amendment, your judgment will be called into question if you place into office one whose life and behavior is at variance with that. So the people will judge us. It's not just us judging whether or not the applicant has good judicial behavior or good judgment. And I would suggest to you that had he left the military and pursued the cause, the case would be somewhat different. But we are not in the habit of appointing people which would be called judicial activists in Virginia, whether you're from the liberal side of the fence or the conservative side of the fence. It's not what we do. And so I would urge a rejection of the application.
Gentleman from Prince